Good afternoon, everyone. My name's Scott Tate. Actually, I don't know if you can see me or not, but I am up in the corner. I want to welcome you to our, Chamber University Business Education Series. We've got Ruth Binger and Katherine Flett joining us, and they are going to be talking about maintaining a legally compliant work environment and navigating the new workplace in the face of COVID-19. So welcome. Also, I want to thank the Villages of St. Peter's Memory Care. And we have Kiva from Villages of St. Peter's joining us. So I'm going to turn it over to her and let her say a few words about the Villages of St. Peter's.
Thank you, Scott. Good afternoon, everybody. I'm excited to see everybody. So we're a licensed assisted living memory care. We specialize in giving warm attention and care to our neighbors living with Alzheimer's or some form of dementia. And our community is designed around a village concept. So it has 4 intimate neighborhoods, and each offers a nice warm home-like atmosphere with a living room, a dining room, a kitchen, and we're nice and small. And as cliche as it sounds, we're like a family because there's not a lot of us. We are accepting admissions right now. So if you guys know anybody that maybe it's time for them to have a break, and it's time to move their loved one in a community that can care for them, feel free to have them reach out to me and give me a call.
Well, perfect. Well, thank you. And thank you for the continued support of Villages of St. Peter's Memory Care towards the Chamber. We certainly appreciate your ongoing support. So
thank you, Scott.
Thank you. With that said, what we're going to do is we're going to go ahead and turn it over to Katherine and Ruth, and I will get their slides set up here. So I'm going to remove that one, and we will add this one, and let them start their presentation. So I'm not sure. I believe Katherine, you're going to go first. I guess let you get started then.
Sure. Hello, everyone. The title of this presentation is Keeping Your Business in Business, Employment and Business Strategies During the Pandemic. And I have with me Ruth Binger, who I will allow introduce herself.
Oh, hi, everyone. Thank you for inviting me. I am a lawyer practicing in Clinton, and I've been doing employment law for over 30 years. And so much has changed in the last 3 months. So I hope to guide you with respect to what happened in the past and what's applicable right now under the existing rules. Thank you again for inviting me. Okay.
Perfect. Really quick before you guys get started, you guys might need to turn your volume down because I think, are your offices next to each other? Because we're hearing a little bit of feedback. So
no.
They're not? Okay. All right. Well, continue on. We'll see if it continues.
All right. Well, hello again, Katherine Flett. I am a member of the litigation team at Danna, McKitrick. I primarily assist clients with insurance-related, business-related, and civil litigation matters. I specifically am interested in the employment realm of things, which is why I'm presenting to you on this topic today. So the way that we have set this presentation up, we've broken it up into 2 parts. The first part is going to be 4 strategies for keeping your business in business. And these are just 4 of the typical strategies that we've seen and recommend. The second part is going to be 10 frequently asked questions. And these are just going to be our recommendations as to best practices with regard to issues that we've seen come up a lot in the last few months. So what we're going to do is we'll do part 1. And if you have questions, feel free to, I believe you can type them in as we go along here. And after part 1, we'll take a little break for questions, and then we'll do the same after part 2. So, but feel free to type your questions as you think of them so that you don't forget. So part 1, 4 strategies for keeping your business in business. First strategy, we've seen a lot of this in the last 3 months, furlough and termination. Your company may choose to continue in business by terminating some employees and furloughing others. Really the only difference between termination and furlough is essentially laying off employees with a definite date of return. It's important that if you are furloughing, to check with your state unemployment office to see if employees are permitted to file both for unemployment and not look for a job. I'm sure many of you are aware under the CARES Act, a lot of the employees were entitled to a $600 supplement. That's scheduled to end, I believe, at the end of July 25th. But that's just something to be aware of too. Another thing is to be careful about if you're treating your employees differently. Use objective business-related criteria when you're deciding who to furlough and terminate. Just some examples you could use: seniority, performance evaluations, attendance, ability to do a cross-section of jobs. Those are all things that you can use. We like to recommend what's called the disparate impact analysis. Requires you not only to ask, is this discriminatory, but could this appear discriminatory? For instance, if you decide to furlough all of your employees that have been there less than 5 years, but all of those employees, it happens to be all of your female employees, we would recommend that you consider that before you do that. Like all of employment law, once you pick a strategy, it's important to just apply it consistently to manage discrimination claims. You should also be aware of what's called the WARN Act. This is a federal law that applies to large companies, usually 100 employees or more, that requires certain notice if you're going to furlough or terminate. In any event, you should always talk to an attorney before you do that, but there's very specific things that you need to do. And we have attorneys at our office that are prepared to assist in drafting such a notice. Strategy number 2, allowing employees to work from home. This is another really common one that we've seen. I know that I've been working from home. So if you do this, it's important, again, to take into account this discrimination test. Ruth is going to talk more about the Americans with Disability Act, the ADA. But it's important that you not just pick all your sick and old people and say, hey, you have to work from home. That's not how to do this. Under the ADA, you have to reasonably accommodate qualified employees who can perform essential job functions. And they require what's called the interactive dialogue with an employee who's requesting an accommodation. So we'll get more into that a little bit later, into some of the frequently asked questions. But it's probably pretty common that employees are asking employers right now, based on certain conditions that they may have, to work from home. When having your employees work from home, you should also keep in mind the Fair Labor Standards Act with respect to hours worked. You need to make sure that everyone is keeping track of their hours worked, and it's important to have expectations and be specific with your deadlines. You have to keep in mind that hourly employees do have to be paid for all hours worked. So if someone is working overtime, you have to don't forget about that either. It's just really crucial during this time for management to step up and make frequent check-ins with their employees who are working from home, whether this is via Zoom, which I know a lot of us have been doing lately, or Skype or IM. Just important that, especially when your employees are working from home, to keep in contact with them regularly, check in on them. All right, I'm going to turn it over to Ruth for strategy number 3.
Okay, strategy number 3 and strategy number 4 relate to the Fair Labor Standards Act. So under the Fair Labor Standards Act, you have to pay employees time and a half for hours worked over 40. You also have to pay minimum wage. In order to be exempt, an employee has to fit within 3 categories. An exempt employee is not the same thing as a salaried employee. An exempt employee is somebody who fits into 3 categories. If that employee doesn't fit into the 3 categories, the exemption is lost for the entire class of engineers, secretaries, whatever profession is in front of you. So that's why understanding the Fair Labor Standards Act is so important here. So with respect to the Fair Labor Standards Act with an exempt employee, you have 3 issues. They have to fall within the salary level test, which is in the 3rd bullet item, $684 per week. It's about $35,600 a year. So they have to get that salary every single week, whether or not they work 20 hours or 100 hours. So that's the quid pro quo with exempt. You don't pay them overtime over 40, but then you don't dock them when they go under 40. The other test is the salary basis test, which is the docking test. And the last test, which is a really hard test, is you have to fit into one of 5 categories. and they're hard to fit into. So you're a manager of over 2 employees, and you can hire and fire as one of them. So that's called the executive exemption. The second one is computer. That's a little tricky, but you're coding. You're doing something very significant. You're not just the desk clerk. 3, a professional, a lawyer, a doctor, an accountant, an engineer, an architect. Those are professional. And then the 4th one is an outside salesperson. So if you're going to reduce the work week, what comes into effect is that you cannot reduce the pay of the exempt employee. So the pay has to stay the same. So you have to be aware of that. So if you intend to reduce the work week, it's not a big deal for hourly employees. It is for them psychologically and their paycheck, but it's not for you because you just have them work less and you pay them for that time. There also is a shared work program under Missouri law, and that allows the employee to both work for you and collect unemployment on a prorated basis. With the CARES Act, if you get $1 of salary or $1 of unemployment, you get the $600. But again, that's going to end on July 25th. And I guess Governor Parsons has said that as of July 5th, people will have to start looking for a job if they're on unemployment. So with respect to adopting a reduced work week, if that allows you to keep your business open or stay in business, it's a good strategy. You just have to make sure you carefully work through the issues related to the Fair Labor Standards Act. Okay, I'm done with 3. So I'll go on to strategy 4. Okay, so 4 is the other side of this, and this is reducing pay without reducing the work week. So again, it's Missouri does have a statute, last bullet item, which says that if you're going to reduce someone's pay, you have to give them 30 days notice in writing. There's not a big penalty there, so a lot of employers ignore that. So employers can reduce someone's pay. That doesn't mean the employee will stay with you, or that the employee could quit and collect unemployment, because if you substantially decrease pay, then the employee can quit and try and find another job and collect unemployment. But with the trick again here is with the Fair Labor Standards Act. You can't go from exempt to hourly, back to exempt, back to hourly. It doesn't work. So what you can do is give notice and say for the next 3 months or the next 4 months, we're going to reduce pay. But you cannot reduce the exempt employee below $684 a week or $35,000 a year. And again, you can work them as many hours as you want, but you can't reduce them past that amount. And it has to be a definite period, because they won't allow you to go back and forth, because then what you've actually done is turned the exempt employee into an hourly employee. So there's some wage and hour cases where, like Walgreens said, okay, for the next 4 to 6 months, we're going to reduce your pay. We don't need pharmacists all the time. We don't make as much money. And the Department of Labor said that was okay. So employers have a great deal of latitude here. They just have to be aware of the Department of Labor that enforces the Fair Labor Standards Act. And I think that's it.
Does anyone have any questions about part 1? Lori, Scott, has anyone typed any questions in?
Nope. So far, I was getting ready to say, it looks like we're good to proceed. So go ahead and proceed.
All right. Easy crowd.
Right.
All right, I'm gonna have Ruth introduce part 2.
Okay, part 2, we put together 10 questions, and then we answer them through this PowerPoint and through our presentation. Some are simple questions, and we will backfill some other issues that come up with related to those questions. But they're the kind of questions that are coming up all the time. They relate to OSHA, CDC, and ADA. And OSHA and CDC seem to change every day. So we want you to know that this is time-stamped as of today, because next week there could be a new rule to apply here. So again, this is time-stamped. So am I up, Kate?
Yep, you're up.
Okay. When an employee calls in sick, what questions can I ask them? So you could always ask the employee questions with respect to when they call in sick, because we need to know if it's a one-day thing, if it's an FMLA issue, etc. So the employer was always allowed to ask the question. The issue is under the ADA, you can't make disability-related inquiries except when you hire someone as a precondition of employment, or if it's job-related and consistent with business necessity. Those were really hard tests. So prior to this, you couldn't really dig deep and ask people random questions in the hallway. How you doing? You have COVID-19. That has changed, and the ADA has a whole section on the pandemic. And it's okay if, and this is the first bullet item, if it's in compliance with the CDC and OSHA. So your guideline is CDC and OSHA and getting on those websites. We have a COVID-19 resource center. We try to keep up with the law and post. Our lawyers have been writing articles furiously for the last 3 months, trying to keep you up to date with the anything related to COVID-19, which would include this, which would include business interruption, would include the PPP. Anything that's related to COVID-19 is on our resource center. So I also recommend you check that. We also have good links for you also. So the ADA or the EEOC has come out and said that the pandemic is a due threat. And because it's a due threat, the employer can ask questions. So you can, and I'm sure you're doing this, you can take the employee's temperature, you can inquire about their symptoms, and the CDC has a long list of symptoms now. It's like 6 or 8 things right now, and you can try and figure out if there is a COVID-19 issue, if there's an issue with respect to current employees. Do you have to tell other employees to self-quarantine? And we'll get into this a little bit later, but OSHA requires you to report anybody who has a COVID-19. Again, we'll get into issue at your work under certain circumstances. So you're almost, I would say, best practice is to inquire. You can also, you can tell someone to stay home if you think it's a medical reason. Now, under the ADA, you're required to enter into an interactive dialogue and accommodate employees. But because of COVID-19, asking the employees these kind of questions and asking them to get on the CDC checker, et cetera, it would be okay because, again, the pandemic is a threat and the EEOC recognizes that. I think we're good. Do I have the next one too?
Yes.
Okay. So influenza, the vaccine is not a due threat, according to the EEOC. So therefore, you can't require your employees to have a COVID-19 vaccination, to have a flu vaccination. However, COVID-19 is going to be vaccination. It's going to be based on what the CDC says and what OSHA says, and they're going to require a vaccination for all employees. So if one does become available, which is supposed to be at the end of this year or the beginning of next year, then I am positive that you will be able to require all of your employees to have a COVID-19 vaccination. You can also ask employees to wear protective equipment, observe infection control practices, which is social distancing, etc. Now, some employees are going to say, I don't want to wear a mask. Well, as the employer, you can say, you know, this is a job, and if you want this job, you have to wear a mask. But if the reason they don't wear a mask is because it makes a medical condition worse, or it doesn't help them do their job, et cetera, then you have to enter into the interactive dialogue with them and try and figure out why they don't want to wear a mask. What I have found is that men seem to like face shields better than masks, and the jury's out which one's better. But face shields may be the way to go if it's not a medical reason, but it's a preference and you want to keep a good employee. So I think that's it. Okay.
And number 3, I think Ruth just went into this, but can our company require employees to get flu vaccines? And again, the answer is no. This is considered a prohibited medical exam under the ADA, and it could also violate a religious belief. So generally, ADA-covered employers should consider simply encouraging employees to get the flu vaccine rather than requiring them to take it. All right, number 4 is Ruth's as well.
Okay. So again, these questions relate to the ADA, OSHA, and CDC, and then whatever the state requires and whatever other governmental entities require, like the county or the city, wherever you are. So the question is, what if an employee refuses to return to work due to fear of contacting COVID-19? The CDC, OSHA, Missouri Division of Unemployment says it is not enough to refuse to return to work because of a fear. So fear of contracting or being exposed to COVID-19 is not a qualifying reason. Now, that's not the end of the analysis, because you have to dig into what the fear is all about. So there's a 3-step analysis, which is there. And then you ask, is the employer requesting leave based on a qualifying reason? So under the FFCRA, you can get up to 2 weeks of emergency pay, which can be from 2/3 to 100% of your pay. And I listed all of these, and I think you've had some webinars on this particular issue. So it's possible that they fit under one of these scenarios. Somebody in their home has it, and they are caring for a sick child or whatever. So the first thing is, does that CARE Act apply? Does the Emergency Leave Pay Act apply? Then the second analysis is, does the employee have a disability where you have to go through the interactive dialogue? So, you know, it's possible that it's significant enough that they can telework, or you want them to telework, or maybe it's not a job that they can telework in. Sometimes I get scripts from physicians saying, I believe this person should not work for 3 months. Well, that because of they're pregnant, or they have MS, or whatever the situation is, and that on its face is not enough. You have to dig a little bit further. You have to try to telework, and then you have to look at the job and enter into the interactive dialogue with the employee to try and figure out what the employee can do. You know, some employees can stay in an office, only come in on the weekend. There's things employers can do to accommodate if there's a disability issue under the ADA. Also, they may require, because they're continuing to see a doctor, they may be able to get FMLA. And FMLA is for employers who have over 50 employees in a 75-mile radius. So it's possible that they meet the FMLA standards, so they can go out for 12 weeks of unpaid leave, where the emergency leave is paid. So you have to go through that analysis. And the third one is, do the state and local laws require you to give the employee leave? So with these shutdown orders, except for essential businesses, many companies shut down and the employees could not work. So they're not covered under the FMLA, but they may be covered under the Emergency Care Act prior to shutting down. So it gets a little complicated to put all the issues together. But the answer to what can a company do about employee refuses to return to work due to fear, you could only let them go if you go through that 3-step analysis. And I think that's all I can offer on this right now.
Question number 5, can our company require high-risk employees to work from home? The answer here is no. The employee must ask to work from home. So as Ruth has explained, the ADA gives the employees the right to request a reasonable accommodation that would allow them to do their job, and it would let the employee sue if they are unfairly denied one. So employees with qualifying disabilities that put them at high risk for the complications of COVID-19 may request working from home as a reasonable accommodation. There was just some recent guidance issued by the EEOC on the 11th of this month regarding a lot of people. I'm sure this has come up where employees are afraid to come to work because they have, someone at home with a, asthma or elderly parent living with them. And so they're afraid to go to work for risk of bringing something back to someone at risk. And per EEOC, per their guidance, that's not enough. Again, you need to go through those steps, because you can't just refuse to come to work because you're afraid to spread the disease. Anytime a reasonable accommodation is required, the employer is required to keep this information confidential. And another thing to consider is employers should not assume that all disabilities increase the risk of COVID-19 complications. And I know that there's been continued research about this, but I know asthma and certain issues surely complicate the COVID-19, but some don't. I mean, vision or mobility disabilities would not increase their risk or create complications for COVID-19. Question number 6.
Really quick before you move on, we did have one question, and it pertained to FMLA. So let me bring it up here on the screen. They want to know, if a business is small enough and not subject to FMLA requirements, how do these practices and rules vary? Can you guys answer that?
Okay, I will take that. I'm not sure what business and these practices and rules vary. So FMLA is 12 weeks of unpaid leave. The CARES Act allowed employers with under 500 employees, or required employers with under 500 employees, to provide 12 weeks of, or 10 weeks of paid leave and 2 weeks of unpaid leave, unless you fall into an exception, which is really hard to fall into. So a small business has 25 employees. An employee has to take care of a child because the child has no child care because of COVID-19. Then the employer has to offer 12, they're going to get 2 weeks of emergency care under the CARES Act, or emergency leave paid, and then 2/3 for 10 weeks under the extension of the FMLA. It's complicated, but even though the FMLA does not apply, the CARES Act extended FMLA for one situation, and that situation is if you have to take care of a child because there's no child care available because of COVID-19, like the school shuts down, etc. Is that helpful?
Yeah, I'll say yes. So
Okay.
hopefully that helped the individual.
All the other laws
Very good.
apply. Excuse me, like ADA still applies. ADA is over 15 employees. The OSHA and CDC applies to all businesses. All the other things I've been talking about apply.
Okay. Very good. All right.
All right.
Let's let you guys move on to the next question, I guess.
Great. Question number 6. If an employee comes to work and is visibly sick, can I make them go home? The answer here is yes. This is a direct threat to the workforce. What does it mean to be visibly sick? That's kind of a difficult determination, but there are specific symptoms of COVID-19 that have been released, and those symptoms are fever or chills, cough, shortness of breath, difficulty breathing, fatigue, muscle or body aches, headache, loss of taste or smell, sore throat, congestion or runny nose, nausea or vomiting, diarrhea. So those are pretty broad symptoms, right? That's why it's important to urge your employee to use the CDC self-checker. And we've included a link there. This is actually, I did it yesterday just to see what it was like. It's really a neat program. It's a chat kind of feature, and it'll just ask you, where do you live? Where have you been? Have you been in contact with anyone who may have contracted COVID-19? So that's it's a neat tool, and I would urge your employee to use that if this situation were to come up. Question number 7, can our company require all employees to take health risk assessments? The answer here is no. You guys may be familiar with these health risk assessments that are offered by many health insurance companies. They're voluntary. And these assessments contain disability-related questions that are not related to COVID-19. Which is prohibited by the ADA. So these can be taken voluntarily by your employees, but you cannot force them to do so. Again, if it comes down to COVID-19 symptoms, I would suggest urging them to use the CDC self-checker. Turn this one over to Ruth for question 8.
Okay. If there's a positive case of COVID-19 within our company, what information can we disclose about the employee who tested positively? So we took the easy way out here and we made the question very narrow, so I will broaden it a bit. You can't say anything. You can say there's a COVID-19 situation here. You can't name the employee, etc. So the employee has to go home. So then you have to, and the employee, you need to follow the guidelines set by state and local authorities. So here are the issues that come up. Was the employee near another person in the workforce within 6 feet over 15 minutes? So OSHA just released a bunch of guidelines on this, because if so, then you may have to tell that employee to self-quarantine. And the rule is 14 days. Then OSHA requires that you tell them of a COVID-19 situation. However, again, this was just posted on the OSHA website. There are exceptions, and you're supposed to sit down with the employee and try to figure out if the employee got COVID-19 at work or someplace else. Like, ask questions, who did they come in contact with, anybody sick at their home, etc. If those questions seem to illustrate that another person had COVID-19 and now they do at work, then you have to report that to OSHA, which makes it very difficult. So then the issue is, okay, so you have an employee who was within 6 feet of the person who's staying home because of COVID-19 for over 15 minutes. What do you do with that employee? Do you have to make that employee go home too under the OSHA and CDC rules? There is an exception that the OSHA just posted in the last week or so that says for essential businesses that are listed as essential businesses, and most of you know what essential business is because you either took the approach you were an essential business or not. But the workers who work for essential businesses, if those workers who fail that test, they were within 6 feet and stayed more than 15 minutes, can continue to work if you meet like 6 elements. And those 6 elements is the person is asymptomatic, you do a temperature check every single day, they wear a mask, they stay away from anybody, social distance, and you go through their symptoms every day. If that is true, then you don't have to send that essential worker home, which is always one of the big issues. If you have a COVID-19 employee, someone who's tested for COVID-19, I mean, what happens with everybody who interacted with that person? So you don't want to, you're towing the line. You don't want to shut down your company. But on the other hand, if you're not careful, maybe it will spread in the workforce. So OSHA has helped, I think, with that issue in the guidelines they have issued in the last week. And then the last thing I note here is that the CDC does not recommend requiring an employee to write a doctor's note or a positive test result. It's fairly easy in St. Louis City and St. Louis County to get a test now. Hopefully they come back pretty fast. And hopefully the employee who thinks they have COVID-19 doesn't have it. So a situation, an employee works for you, she goes to the doctor because she's just doing a checkup on her lungs. And the doctor said, your lungs look okay, you still have that issue, but why don't we do a COVID-19 test? The fact that the doctor, and if the employee has no symptoms and the doctor still did a COVID-19 test, to me, that does not mean that the employee has to stay home. It's just a physician asking that another test be run, because otherwise everybody would stay home and get paid the emergency leave pay, because then they would be covered under the emergency leave. So you have to dig through it and maybe check some websites, go on our website, call us if you need help. But it gets a little complicated when you have a COVID-19 situation in your workplace. That's it.
Questions number 9 and 10 kind of go hand in hand. Question number 9 is, if an outbreak of COVID-19 originated at the workplace, would this be considered a workers' compensation injury? And this is kind of a hot button issue right now. Really, the difference between a workers' compensation injury or suit versus a private lawsuit type of issue. So the answer here is maybe. Employees who are injured or fall ill because of unintentional accidents or exposure at work are generally required to bring their claims through the workers' compensation insurance carrier. However, workers' compensation generally does not provide coverage when the employer intentionally, negligently, or willfully injures or exposes the employee to harmful substances. The degree of fault is going to be left up for the court to decide. You all may have heard of this recent pork processing plant case, the Smithfield food case. I have the site there on the page. This was a Western District of Missouri case where the employees filed a lawsuit seeking injunctive relief to force Smithfield to provide the employees with masks and ensure social distancing and take other measures to protect them from COVID-19. And the court in that case, which was the Western District of Missouri, kind of threw up its hands and said, this isn't a matter for the courts. This is a matter for OSHA to decide. There was a recent case filed in California. This was a McDonald's that was being sued for something pretty similar, and the California case came out the other way. California court actually required the McDonald's to shut down. It granted a preliminary injunction requiring them to shut down until they could ensure that they were ensuring proper guidelines, social distancing and wearing masks and other things that were required by the laws there. So it's really, it's a changing legal landscape. It's going to take a lot of time for us to kind of figure these things out, weed through these issues. But really, in the Smithfield case, they said this is a matter for OSHA. So OSHA has issued a ton of different guidelines. They require employers to furnish employees with a place of employment free from recognized hazards likely to cause death or serious physical harm. And it does require for employers to provide PPE whenever it's necessary by reason of hazards of environment encountered in a manner capable of causing injury or impairment through absorption and inhalation or physical contact. So it's provided their initial guidelines, and there's more coming out every week. It's just really important to keep track of this rapidly developing legal landscape. And it leaves employers oftentimes just trying to figure out, what's the best practice here? What can we do? And really our recommendation here is just to keep track of OSHA guidelines and the CDC guidelines and make sure you're doing everything you can to abide by those. And the other hand on this is question number 10, is can an employee sue our company for not protecting them from COVID-19? The other side is, not the workers' compensation claim, but filing a lawsuit, for a private lawsuit. And there was this Walmart case that was filed in April, which some of you may have heard of on the news. And in that case, the allegations were that Walmart failed to clean and sterilize the store. They failed to implement, promote, and enforce social distancing guidelines. They failed to provide proper PPE to employees. They failed to warn the employee that other employees at the store were exhibiting the symptoms of COVID-19. They ignored employees who communicated to management that they were experiencing COVID-19 symptoms. They failed to follow the OSHA and CDC guidelines, and they failed to train employees to implement and follow employee health and safety protection guidelines. Of course, these are all allegations in a lawsuit. But the court in that case, which is an Illinois court, they have allowed this case to move forward. And as you can see, the difference here is there was evidence apparently that they knew that some of their employees had these symptoms and were just either ignoring it or failing to warn those other employees that they could be at risk. So back onto the workers' compensation side of things, it's really difficult. You still have to prove that you contracted COVID-19 at work. Under most circumstances. And this is different from the mesothelioma cases where you can point to asbestos. I worked around all of this asbestos and this caused my mesothelioma. There's causation there, right? If you, drop your kid off at daycare and then you go to work and then you go to the grocery store afterwards and all of a sudden you contract COVID-19, how can you prove that that was caused by your workplace and not the daycare or not the grocery store or whatever else you did for the days before and after that? So the causation element is difficult to prove here. However, a lot of states have relaxed this burden. In Missouri, Governor Parsons has issued an order that if a first responder contracts COVID-19, there's an automatic presumption that they contracted it at work and that they are entitled to receive workers' compensation. And Illinois has passed a similar order. So state laws are changing rapidly. Again, it's just really important to keep track of those. And so while workers' compensation law typically blocks workers from filing private suits over workplace injuries, that bar is not absolute. So employers may be facing disputes from several angles here. So it's just really important, again, best practice to follow these CDC and OSHA guidelines and operative government regulations to really do the best you can to protect yourselves in these situations. And this, again, this is a law as of today. It's changing every day. It's important to, you can either use our resource center or contact an attorney if you have questions. There's a specific instance that comes up. And this, I guess we can take questions on part 2. I do have a link I wanted to point out. We keep referencing this COVID-19 resource center that our firm has put together. There is a link at the bottom of this, and there's also Ruth and my contact information. Feel free to email us, call us. If you want a copy of our presentation, we'd be happy to email one to you if you email us. But yeah, let's take questions on part number 2.
Okay, so someone has emailed in, where can we get up-to-date legal info? Health info is everywhere. No idea how to stay on top of the legal issues.
So our COVID-19 Resource Center is where I would direct you. I think we've done a really good job of organizing this information, because we've all been bombarded with all of this information, and how do we figure out how it applies to us and our business? And I think that if you go to our website, you'll see that there is just great resources, and it's well organized and easy to understand. But of course, you can always contact Ruth or I or an attorney to ask about specific questions.
I also think the bottom line is that if you stay on the CDC and the OSHA website and you follow their recommendations, you probably will be able to protect yourself against liability, either workers' comp or another type of lawsuit. That's all you have. I mean, really what's happening is the EEOC has bowed down and said whatever the CDC and OSHA says, we'll go along with it, because it's a pandemic and it's a threat. So I wouldn't worry. I mean, the legal landscape is going to change dramatically. In 2008, when we had the recession, 2009 and 2010, all sorts of lawsuits on everything. Next year and the year after, there'll be tons of lawsuits. And what Ruth said, the law will develop. Some states are going to be very harsh on employers. Some are not. Right now, Missouri is not. Some people are going to get business interruption insurance and actually win on that. In other states, they're not. So the law is going to change rapidly. When AIDS first came around, a lot of the law for insurance, employment, etc., changed because of AIDS. This is one of those situations. The difference is it's so rapid. I mean, it's only been 3 months. So that I understand that it's hard to keep up, but if you just poke around CDC or OSHA, I think you should feel you should feel like you're doing what you should. Not that you're going to like the stuff they tell you, because sometimes it's harsh, but that would be your best defense. Any other questions?
I don't show anything else.
Okay.
If you have any questions, make sure you type them in so we can read them and get them answered for you. Give them just a second to type it in.
Sure.
Anybody else have any other comments, questions? I'm not seeing any pop up. So I guess with that, we'll go ahead and conclude today. I want to make sure we thank our sponsor, Kiva, again, over at Villages of St. Peter's Memory Care. And also thank you to Ruth and Katherine for being our experts today. So you saw their contact information on the screen. So make sure you email or call them if you have any other questions at the end of the day, anything else comes up. So thanks, ladies.
Thank you.
All right.
Thank you for having us.
You betcha.
Take
We
care.
do have another Chamber U coming up on July 23rd, it looks like, and it's going to be about Missouri employers and medical marijuana. So make sure you check out our website and register on that for that seminar. So until then, everybody have a safe 4th of July, and we'll see y'all soon.
Take care.
All right. Thanks, guys.
Thank you.
Bye-bye.
Bye-bye.